All right, so welcome everyone. I'm calling to order the meeting of the Sentencing Guidelines Commission. It's April 10th, 2025, and I will ask Director Wrights to read the roll.
Roll call, Vice Chair Larkin.
Present.
Larkin present. Commissioner Fraze. Commissioner Fraze.
I think he's online.
Commissioner Fraze absent. Commissioner Keefe.
Present.
Commissioner Keefe present. Commissioner Knudsen.
Present.
Commissioner Knudsen present. Commissioner Ladd.
Present.
Commissioner Ladd present. Commissioner Mazzaros.
Present.
Commissioner Mazzaros present. Commissioner Middlebrook.
Present.
Commissioner Middlebrook present. Commissioner Moore.
Present.
Commissioner Moore present. Commissioner Morin.
Present.
Commissioner Morin present. Commissioner Mueller.
Present.
Commissioner Mueller present. Commissioner Reeves.
Present.
Commissioner Reeves present. Commissioner Saxena.
Present.
Commissioner Saxena present. Chair Mitchell.
Present.
Chair Mitchell present. Commissioner Fraze. All right, Commissioner Fraze absent. So Madam Chair, there are 12 members present, 1 member absent.
All right, so with that, we do have a quorum. One sec here. So moving on to the first item on our agenda is adoption of the draft meeting agenda. I would entertain a motion to approve the agenda. So moved. Commissioner Larkin moves, Commissioner Middlebrook seconds. Any discussion on the agenda? Hearing none, we'll take a vote on that.
To the Larkin motion to adopt today's meeting agenda, Larkin.
Yes.
Larkin, yes. Fraze. Fraze absent. Keefe. Keefe. Knudsen. Knudsen.
Aye.
Knudsen, yes. Ladd.
Yes.
Ladd, yes. Mazzaros.
Yes.
Mazzaros, yes. Middlebrook.
Yes.
Middlebrook, yes. Moore.
Yes.
Moore, yes. Morin.
Yes.
Morin, yes. Mueller.
Yes.
Mueller, yes. Reeves. Reeves.
Sorry, had technical difficulties. Yes.
Reeves, yes. Saxena.
Yes.
Yeah, Saxena, yes. Mitchell.
Yes.
Mitchell, yes. Keefe. Madam Chair, there are 11 votes in favor, no votes opposed.
With that, the motion is approved. Commissioner Keefe, you did come off mute, but we didn't hear you. So I'm not sure if you're having any difficulty. I'd like to do a sound check if we can before we move on. So you came off mute. Can you say something? Sounds like we're not hearing you, so you might want to try logging off and logging back on. In the meantime, we'll move on. Did you see was there a chat? No, but I heard some. Okay, so in the meantime, we'll move on to the next item on the agenda, which is approval of the draft meeting minutes from March 13th, 2025. I know that I submitted a couple of corrections, so how do you want to handle that?
Thank you, Madam Chair. And Commissioner Middlebrook also pointed out some errors. So I'm going to just, if I could, Madam Chair, walk us through the errors. So
Okay.
I'll get it. So most of them are in the nature of typographical errors. The first is page 5. It's on the, after the four numbered paragraphs on the first line following that. Director Wrights concluded his discussion of principles and processes by brining, should be bringing. The second is on page 8. That's striking after the word discussion. The first word following discussion is commissioner. That should just be commission. The
Wait a minute, go back to that page.
yes.
So,
Strike ER.
yeah, but for the third, fourth, and fifth paragraphs, it's the same problem. It says commissioner members.
Oh, yeah. Okay, so that would be in 3 different places in that paragraph, 4
Mhm.
different places,
Yeah,
commissioner members. So then on page, so that's page 8. Then next is on page 9, where the paragraph that says director writes his first update. The sentence beginning with the word second, suggested should be suggesting. And I would put a comma in front of that. So the sentence would read, second, he commented on the February budget forecast update, comma, suggesting that the commission would not be receiving any more funding to support the next phase of the comprehensive review. And then the last, and this is really less, I think this is more just for accuracy's sake. And this is right before the action on the motion.
a motion to
To
support.
support Senate File 1719. At the first sentence on page 10, based on the diversity of opinions of the matter. And then instead of Chair Mitchell suggested that judicial involvement be discussed at a future date, should read Chair Mitchell suggested that the commission refrain from commenting on judicial involvement in the task force. Leaving, and then it still says leaving the current motion as it stood. So there was no change to that motion, but the reason for it would be different. So are there any questions on any of these changes to the minutes? I apologize for the errors, Madam Chair.
So if there are no questions, then I would entertain a motion to approve the minutes as amended, as we were just shown.
So moved.
Commissioner Larkin moves that. Commissioner Middlebrook seconds. Do we have any further discussion? All right, hearing none, we'll take a vote on that.
Do the Larkin motion to approve the March 13th meeting minutes as orally amended. Larkin?
Yes.
Larkin, yes. Phrase? Phrase, absent. Keith? No response from Commissioner Keefe. Knudsen?
Yes.
Oh, you know what?
I see Keith.
She's down in the panelist. That's why.
Okay.
There's great.
I'll get, Commissioner Keefe, I will get back to you. Commissioner Knudsen, yes. Commissioner Ladd?
Yes.
Ladd, yes. Commissioner Mazzaros?
Yes.
Commissioner Mazzaros, yes. Commissioner Middlebrook?
Yes.
Commissioner Middlebrook, yes. Commissioner Moore?
Yes.
Commissioner Moore, yes. Commissioner Moran?
Yes.
Commissioner Moran, yes. Commissioner Mueller?
Yes.
Commissioner Mueller, yes. Commissioner Reeves?
Yes.
Commissioner Reeves, yes. Commissioner Saxena?
Yes.
Commissioner Saxena, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. The motion before the body is approval of the March 13th minutes as orally amended. We just orally amended it, Commissioner Praise, and I know you weren't in the room for that. Would you like to vote on the motion?
Yes.
And how would you like to
Yes.
vote? Commissioner Praise, yes. Commissioner Keefe?
Yes.
Commissioner Keefe, yes. Madam Chair, 13 votes in favor, no votes opposed.
All right, and I'm glad that we got the sound working for you, Commissioner Keefe, so we can all hear you now. That's great. All right. Next item on the agenda. Oh, now we're moving on to the comprehensive review ranking project discussion. And I think Steph, we're going to start by walking us through the results.
Thank you, Madam Chair. While they're getting set up, I just wanted to sort of give a little preamble as to sort of what we're doing here with the ranking project. So first of all, I want to express my appreciation for all of you for the obviously hard work that you all put in on this. It was a difficult, I'd say first step of doing this ranking exercise. It was a pretty complex exercise, and you all put a lot of work and a lot of thought into it. As far as I think it's probably appropriate to sort of calibrate expectations as to what's going to happen at this meeting. So this is a comprehensive review, and it's not anticipated that the commission is going to take action on different items piecemeal. Instead, it's really going to be, to the extent possible within the limited time and resources that we have, do as comprehensive a package as possible at this point in time. And so what I envision this discussion, what the purpose of the discussion to be, is not so much to reach a decision at this time, but really to inform each other, to inform the steering committee, and to inform the chair as to what the sense of the commission is with respect to these ranking decisions, so that thus informed, the commission, the steering committee, and the chair can put together a comprehensive package of proposals to include any ranking results from this exercise for later consideration. So it's not like we're expecting, this is a discussion item on the agenda, and it's not like we're expecting that the commission is going to take a vote to change a ranking at this meeting. So I just want to put that out there to maybe that will help relieve stress. That no final decisions will be made today.
All right, we're on to the ranking results of the offense group 1. So just a quick recap. Remember at the last commission meeting on March 13th, Director Wrights walked you all through the offense group 1 packet and explained the ranking form. You were all asked to individually complete the ranking forms and send them to us by March 31st. We then compiled all the responses, calculated the total number of responses for each of the ranking offenses, and summarized any notes provided. And so there were 5 subgroupings in this offense group 1 of felony motor vehicle operations. There was criminal vehicular homicide, criminal vehicular injury, great bodily harm, criminal vehicular substantial bodily harm, felony driving while impaired first degree, and fleeing a peace officer.
Can I just make one comment on that March 31st date? That's when we got the commission members' results. The deadline was earlier than that, but I just want all of you who did it on time not to wait, I had an extra week. No, we appreciate all of you that got it on time. There was a commission member who misunderstood the deadline. So March 31st is when we got all the results that we're going to get.
I'm also worried about your sound. So can I put that? I want that. How about if we move this one over?
I'll take this one over. Right. Okay. So hopefully you think that's a little better. We got this one.
Well, we want him to be able to be heard too.
That's true.
Apparently the order matters and it's very confusing.
Okay. So what we're going to do, and this is going to go pretty quick, but Matt and I are going to give a brief overview of each of the 5 subgroups. We're going to present a bar chart showing the number of selections for up ranking, down ranking, no re-ranking. And then we're going to have a slide that highlights some of the comments and notes that you all provided. Please note, we're not going to go through all of the slides that we gave you in detail. We're focusing on the highlights. Also note that we did our best to interpret the comments and notes. Some of them were handwritten and took a little bit of deciphering. So we apologize if we interpreted anything incorrectly. Again, we're going to go through this rather quickly. So if you have any questions, we recommend you hold off on asking, because Matt is then going to come facilitate a conversation about all of the information. I'll hand it over to Matt.
Great. So I'm going to start with criminal vehicular homicide. And like Leah said, we're going to start with a figure that kind of shows the distribution of all of the responses for each offense within a subdivision. And so the blue bars are no re-rank, the yellow bars will be up rank, and the green bars will be down rank. And this is going to be consistent for all the figures that we show. Moving from left to right, we have criminal vehicular homicide gross negligence. And the next one to the right is leaving scene, defective maintenance, while impaired, and a prior offense, and while impaired. And so the first three offenses, moving from left to right, have a bit of a similar distribution where no re-rank and down rank were the most common responses we received, whereas while impaired and while impaired with a prior had a bit more interest in not re-ranking or up ranking. Now on to the highlights section. So for this section, guideline true zero offenses, there were a decent amount of them for criminal vehicular homicide in general. So some responses we received were, should guidelines true zero cases be treated differently, and allowed for presumptive stays at low criminal history scores in general. So not just guidelines true zeros, but presumptive stays at low criminal history scores. Something that was cited frequently was there's a public desire for a higher ranking of criminal vehicular homicide related offenses. Incorporating restorative justice component to the sentence was to account for victim and community impact was something that was suggested, and this would be something incorporated within the sentence itself. It would be a mandated portion of that sentence. And for an example, there would be like chemical dependency treatment for a while impaired offense. Proportionality issues between CVH offenses in general, those with prior convictions, and to DWI offense, that was something that was brought up. So the proportionality for someone that's wild impaired and a prior compared to someone who's grossly negligent was something that was cited. And then defective maintenance seems like an offense that is punitive towards people who are under resourced. So special considerations were given by some people for that offense. Moving on to criminal vehicular injury, great bodily harm. So once again, we have no re-rank, up rank, and down rank. And for this one, we don't have a while impaired and a prior, but all of the other, I'm not sure what term to use there, but we have grossly negligent, leaving scene, defective maintenance, and while impaired. Immediately, this figure should look a bit different than our last criminal vehicular homicide figure, where the majority of these offenses, there was interest in not re-ranking or up ranking, and not a whole lot, not as many responses for down ranking. And with grossly negligent and while impaired receiving the most interest in up ranking. Some highlights for these offenses, or for this offense subgroup, is that these are serious person injury offenses. So the seriousness of the harm needs to be taken into consideration. Once again, public desire for higher ranking of CVI, criminal vehicular injury, great bodily harm related offenses. Some of these should look the same, and it'll be the same once I move on to substantial bodily harm. So, public desire is one of those that was seen across these first three categories, at least, as was incorporating restorative justice practices to the sentence. Something that popped up here was, should the stat maxes be increased? So a few people cited like maybe move it to 7 years for a severity level 5 offense. It seemed like the stat maxes might need to be increased. Defective maintenance appears to penalize people who don't have the resources. Once again, long sentences do not seem to impact deterrence of some offenses due to the mens rea of the defendant. And so this was oftentimes cited for grossly negligent offenses and the while impaired offenses. And something proposed here that will be seen again in severe bodily harm is that should there be a new offense for CVI GBH while impaired, similar to what there is for criminal vehicular homicide. The last group I'm going to talk about is criminal vehicular injury, substantial bodily harm. This distribution is a bit similar to the criminal vehicular injury, great bodily harm, where the majority, the most commonly suggested choices for ranking options were no re-rank and up rank, but perhaps not as substantial for gross negligent and while impaired in the substantial bodily harm category as for the great bodily harm category. And the highlights here, these are serious person injury offenses, use restorative transformative process to allow for accountability for harm to the victim and the community. Once again, the public has provided input that CVO offenses in general are not treated severely enough. Could increase the stat max for these as well. Should a new offense be created with a higher stat max if a person commits a CVI, a criminal vehicular injury, substantial bodily harm while impaired, and has a prior, so similar to that criminal vehicular homicide offense. And then one thing cited here was to review laws imposing collateral consequences for felony DWI to make sure the same requirements are imposed for CVO resulting from impaired driving. I'm going to pass the mic back over to Leah to finish this out here.
All right, so now we're moving to felony DWI, and there's only one offense here. The majority of responses indicated no re-ranking needed for this offense. There were a handful of responses for downranking and one for upranking. As far as highlights, there was a comment about guidelines true zero cases. There's an 87% downward dispositional departure rate for these cases. So should the commission adopt a special rule for the GTZ cases? A perspective that incarceration will not resolve the problem. Rather, there is a need to provide access to and incentivize CD treatment. There were some comments about the stat max, and felony DWI has a stat max of 7 years, while other offenses at the same severity level have higher stat maxes. Is this in line, or is it something that needs to be adjusted? There was a comment that the high departure rates are arguably expected and desirable for this offense if the goal is to have alcohol-dependent offenders give them a strong incentive to enter and stay in treatment and not send them to prison. And a comment about the seriousness of DWI, and it's a public safety risk. There were also a couple of comments that's not up here about wanting more information about who is getting these departures and at what criminal history score. And then the final subgroup is fleeing peace officers, and there are 4 offenses here: death, great bodily harm, substantial bodily harm, and fleeing. For 3 of the offenses, the death, substantial bodily harm, and fleeing, no re-ranking was the most common response, although there were votes for upranking and 1 vote for downranking. For great bodily harm, there was a tie between no ranking and upranking, one vote for downranking. And as far as comments or highlights of those comments, comment about the significant public safety risks, and they vary depending upon location, urban, suburban, and rural. The risks are significant across the board. Fleeing is also a volatile offense that is inherently dangerous. There were multiple comments about the stat maxes. Do they make sense? Do they need to be adjusted? Are they proportional to other offenses at similar severity levels? There was a comment about Black and Latino men being more likely to be in prison for some of these fleeing offenses. And a comment that we've heard before about using restorative practices and transformative justice to account for the harm. A question about, or a desire about learning more about the common means of eluding police. How common are sheer panic cases? Fleeing charges can cover a lot of driving behavior that is dissimilar in terms of the effect of public safety. And then the final comment here that we're highlighting is there was a lot of comments about deferring the ranking until after the 2025 legislative session. So that is our very quick and dirty highlights. I know that was a lot, but now I'd like to hand it over to Charlie and Shamsa from MAD to lead us in a facilitated conversation.
Hello, everyone. That was a lot of information. It's okay. I want us to all use this time to reflect on the information that we all received today. But before we start, I want us to get out of our heads into our bodies, realize it's 3 o'clock.
I'm sorry to interrupt, but it's very difficult to hear at the moment on the virtual meeting. Sorry about that.
Hello, can you hear me better now?
Yes, that's
Commissioner
much
Tree.
better. Thank you.
Of course. All right, it is what time? 3:30. It is late in the afternoon. So I'm pretty sure we all are kind of tired, but I want us to be acknowledge that the work that we're doing today is more than just ranking. This has long-term implications. So with that being said, I think Nate mentioned already that we are not making any agreements on how the rankings are going to be finalized, but we are trying to have a package discussion today and reflect on the values and the principles that you all were deciding on. So if you could all engage with me and set an intention to be thoughtful today and engage with the human impact and long-term implications of sentencing decisions. If you can pull up our slide for. All right, so as a reminder, all right, can everyone see that? All right, so in statutory, you all as the commissioners of the sentencing guidelines have authority to establish non-institutional sanctions. As you can see here, the sentencing guidelines promulgated by the commission may also establish appropriate sanctions for offenders for whom imprisonment is not proper. Any guidelines promulgated by the commission establishing sanctions for offenders for whom imprisonment is not proper, commission shall make specific reference to non-institutional sanctions, including but not limited to fines, incarcerations, and probation. I want to bring in a note here from the federal sentencing reporter. Judge Nancy Gertner, who's retired, mentions in this report, since a guideline sentence is almost as likely to be affirmed as a non-guideline sentence, one would expect to find judges considering creative sentencing alternatives, evidence-based practices, neuroscientific insights into addiction or childhood adversity. One would expect judges critically evaluating, even rejecting, the seriously flawed guideline framework, as the early post-Booker cases suggested. Now, I'm not a lawyer, but I'm pretty sure or hope that some of you all are familiar with what I'm saying right now. When you all took the packets home, if you could individually reflect on what were you feeling and thinking? What helped you make decisions? What values, what tensions were you grappling with? So I'm going to give you all a couple minutes, 30 seconds probably, to reflect. And for the folks who are online, please do interact. What helped you make these decisions? What are the values or the principles that you're grappling with as you're making a decision to uprank, downrank, or not rank an offense?
You want us to just jump in, or
Yeah, go ahead, please.
should we go around the table or go alphabetical?
You can start and then we'll go from there.
All right. Well, in most cases, when we're looking at the defendants like this is not the first time they've had interaction with the criminal justice system. And so for the most part, you know, I'm kind of responding to that last quote that you read. You know, these cases come to us and we get reports and recommendations from probation. And based on what kind of input they see, what kind of rehabilitation efforts they think and know work, and we agree or disagree with probation, and we typically then would issue a sentence. But when I look at this, the system and overall, and when we're talking about re-ranking, I'm really focused on, the proportionality of these offenses with the other similar offenses with similar elements that have to be proven. So I'm comparing similar case types, proportionality to those case types that are less, I guess, offensive, with case types that are more serious above these cases. And basically, what is the public's expectation for someone committing this kind of an offense? So it's just a variety of things. But that's my response to, I guess, your original simple question of what was I thinking when I was looking at re-ranking these, and it was mainly because we're working with re-ranking a guideline system. We're not necessarily looking at what is the best recommended sentence for some kind of probationary, rehabilitative, that kind of thing. But we're looking at, within the context of the existing guidelines and this type of an offense, where does this fit? Is it in the right spot? Is it proportional? How's it compared to other offenses? And does it protect public safety? That's my thoughts.
Thank you for sharing your thoughts, Commissioner Knudsen. May I ask, what were you feeling? The first part of the question.
Feelings, judges don't feel. That's how many times did Catherine Middlebrook ask, well, and how did you feel about that when she's got a witness on the stand? No.
Maybe that's a good question.
Yeah, we don't go there. Objectionable. No, well, I mean, seriously, but it's daunting. You think, wow, if we move this up or down, what is the overall impact? This is kind of heavy.
It is.
It looks like Kyra has her hand up, so she probably wants to jump in.
Commissioner Ladd.
Thank you, Madam Chair. So I'll start out by the feeling part, and I'll just say it's overwhelming and it's hard, and it's very time consuming. Some of my fellow commission members know my approach and how I did this because I'm on the steering committee, and I started with the whole and worked my way down to very specifics. And so by that, I looked at every single offense that's on the standard grid on the guideline. And I looked at what the current ranking was compared to the other current offenses in that same severity level. I looked at what the stat maxes were for severity levels 1 through 11 and asked myself questions about why the stat maxes were, the ranges the way they were. And so trying to give context in all of that, as that when you start looking at specific offenses, helps you understand sort of why you're making the decisions you're making. When you're comparing them to other offenses, you're looking at the harm to who? Is an offense disproportionate to other offenses in that same severity level? Is there some rational or irrational connection with that? Embedded in that is also trying to think from a practitioner's perspective. How are what we're doing in terms of crafting this, aside from all of the reasons why, how are we making it easier and less complicated to use and understand for practitioners and for the public? And so it's difficult because even in this exercise, in reading the notes and the comments, I mean, we start carving out these exceptions, and those exceptions is kind of what takes us down the rabbit hole to making things more complicated, because the nuances to those things, they are complicated matters. So I think it's hard, and I've said this from the beginning, and I'll continue to say this so that the record is clear. I think that this is a hard task because we're only doing a portion of the guidelines in terms of this comprehensive review because we can't do it all. We don't have enough time and we don't have enough money. But it's necessary because I think if we're going to do any re-ranking, I think it sets the whole of the guidelines kind of off kilter because it does create probably more disproportionality or irrationality in similarly ranked offenses by moving some and not others when others should move. And so I think that's the struggle and that's the stress and that's the tension that I feel in trying to do this exercise with the whole of the project.
Thank you for naming the tension. Anyone else want to add to that?
Commissioner Frace.
Thank you, Madam Chair. I second what Commissioner Ladd just said about particularly about the problem of sort of piecemeal changes. One of the reasons the guidelines, I think, were one of the many reasons the guidelines were an improvement is that the Commission looked at the big picture, looked at all the crimes at the same time, went through a process to rank them all at the same time, as opposed to what's sometimes called the crime of the week, where the legislature rightly or wrongly gets concerned about one crime, and then there's sort of a leapfrog problem. So I mean that is a problem. I guess in terms of what I looked at, I didn't look at the statutory maximum that much, unless it had recently been changed, because that would be an indication of the legislature's view, and they ultimately set policy, at least in broad terms. Because the statutory maximum is so for the worst case that falls into that statute, and the guidelines are based on the typical offense, and there may or may not be a sort of a standard ratio between the typical case seriousness and the worst case for a given crime. There could be some crimes that are just so varied. The worst case is really, really bad, but the typical case is not so bad. I did look at the departure rates, and I guess one problem I had in using that as a guide, because my thought would be if there isn't a particularly high departure rate for this crime, then if it ain't broke, don't fix it, or at least be careful of partially fixing it. And what I didn't have in front of me, and I don't know whether staff has this or could easily get this, would be to know we were dealing here with 18 offenses all on the main grid, and we were given departure data for a 10-year period. And I guess I wondered in that 10-year period, what was the average departure rate? And relative to that, where does this crime fall? And I'm guessing that it was probably, at least 35% downward dispositional departure, because it's been elevated for years for all crimes. I'm not sure it's been separately reported by grid. But anyway, I tried to sort of make assumptions about what's the average, and is this one significant? And in some cases, the departure rate for a crime was very significantly greater than what I assumed to be the average, and that is a message. So then the last two things I would say, one is I think I was looking, are there any subcategories that maybe could be carved out? And, grid true zeros certainly leaped out over several times as something which, accounts for a lot of the departures and maybe could be handled separately, either offense by offense or with a general GTZ rule. And then I guess I was the one that made the comment about the high departure rates. Sometimes it's an indication that, the guidelines recommendation is just out of step with the consensus of practitioners and judges about this crime. But it can also mean that there's an apples and oranges problem, that things are being over aggregated. Again, can we drill down, zero in on the subcategories that really have the true high departure rates? And then I was the one that made the comment about felony drunk driving, that I may be wrong, but I thought that historically the reason that was made a felony was to give chemically dependent alcoholic offenders a strong incentive to get in treatment, stay in treatment, with the prison sentence hanging over their head. And if they're amenable, and if there are programs for people, and some of them are amenable, a suspended sentence, a downward dispositional departure could be exactly what we're trying to do with some of those people. And I guess you could broaden that. I'm not sure that I can give another example, but I mean, I have for a long time taken the position that one of the geniuses of the guidelines, as I viewed it, was the way in which it used suspended sentences, and in this case, downward dispositional departures, as a way to balance the very competing considerations. So that we could say, well, we condemn the crime itself, the harm, potential harm, with the seriousness of the prison sentence, whether it's executed immediately or not. But we send that message. We also hold in reserve the ability to execute it if this person, we can't work with this person in the community. Downward dispositional departures, I think, are above all based on amenability to community-based sanctioning. And I think that system, it strikes a balance. I think it's worked well.
Thank you for that, Commissioner Reyes. Before we move on, I just want to make sure that you all are not talking at each other. I know we have a lot of academics and a lot of lawyers in this room, but for the folks who are not well versed in the legal jargon, let's try to please engage with each other and be more interactive. Commissioner Logan.
Okay. In terms of feeling, I think what I'd like to address maybe is my perception of how many feel about this particular offense, which is based on my being a public defender in Hennepin County for 13 years, district court judge for a couple years, and now Court of Appeals 17 years. In my experience, drunk driving is an offense where the focus is heavily more so on the defendant and what we can do to help the defendant than any victim that was harmed. And there are plenty of drunk driving offenses where you're pulled over, no one's hurt, but there are head-on collisions. There are horrific accidents. People are killed, people are maimed, children are killed, kids are killed walking to school. And I've seen frustration in the courtroom by victims and by the public who feel like all you're concerned about is the defendant and what are you going to do to help the defendant and keeping the defendant out of prison, you know. And it seems to be the type of crime where the victim gets lost more so than other cases. And I always wonder, why in Minnesota do we love DWI so much? And it's not academic. I just think there's a little bit of, but for the grace of God, I could have been driving that car after a happy hour. It could have happened to me. So we tend to be very forgiving. And when that happens, I think it really re-victimizes the people who've lost a loved one, or the person who's been harmed, or the person who, you know, has lost their income or lost their car or now has to go to court proceedings. It seems a little off balance to me because there's quite a bit of sympathy for the defendant in that situation. And, you know, we've heard the comments, I've heard them as a judge. There are no consequences for this offense. You know, this is the fourth time, the fifth time, the sixth time. And I can tell you as a former PD and as a judge, you know, people are offered treatment over and over and over. Kind of the notion that, well, you get to the felony DWI level and you've never really had the opportunity to go to treatment. That's not how it is. First of all, it's 3 and 10, right? So I'm a little bit frustrated by this offense. And I see this as an opportunity to at least, you know, to the extent there is agreement, to maybe treat it a little more seriously, which we've not done. And even with the legislature treating it more seriously by making it a felony, we get these high departure rates, so it's not really made more serious. And I also know, as a judge, there were times where we would put people in jail or maybe a short prison sentence because treatment hasn't worked for, you know, 3, 4, 5, 6, 7, 8 years. And at least we could keep them sober against their will for a year. Maybe that would put them in a better position. So I'm just feeling like I want us to look at both sides of this issue and not just the defense.
Thank you.
Looks like Judge Knudsen raised his hand.
Judge Knudsen,
Oh, you're on mute.
unmute.
I don't want to keep going on about the felony DWI, but I think I have to, as one of the authors of that felony drunk driving felony DWI, as well as the .08. We did not do this to give somebody another chance or to hopefully get them to comply with probation. We did it because it's the fourth offense. It's the fourth offense. And I think as I look back on this in my career, and we were sitting in Amy Klobuchar as the county attorney was prosecuting in Hennepin County, a gal that was on her 21st drunk driving offense. And we just said, we can't keep this up. It's literally killing people. And so where do we go with this? And so we passed, we got .08, we got the felony offense. And, but as a judge, of course, it's not easy sending people to prison. It's very difficult. But I think what's happened, and this is just my empirical look at drunk driving offenses. If you came into court when I first started practicing law with a drunk driving offense, you were going to jail. No ifs, ands, or buts for probably 7 days, probably a week. Well, and then as we go on, we're going to treat the offender, and then it's a weekend. And now it's nothing until we hit the mandatory minimums of the 6 days, the 30 days, the 180 days. And then even when we get to the felony, it's going to be some jail time. But we don't ratchet it up because we don't start anywhere. And then all of a sudden it's the fourth one, and then we're looking at prison. And there's never been any consequences to this defendant before, and they're looking at prison, and it doesn't seem fair, or it doesn't seem right, because it's just drunk driving. But when you go out door knocking and you meet the mother who lost her son in a drunk driving accident, and you deal with that in the courtroom every 2-3 years, something's got to be done. We're not treating this offense the way it needs to be treated to stop what's happening on our highways. That's my thoughts on this.
Thank you, Commissioner Knudsen. We've heard from 2 judges. I would like to invite sorry if I pronounce your name incorrectly, but Commissioner Mazzarnos, Commissioner Keefe, Commissioner Saxena, if you all have a different preferring perspective in regards to the roles you play.
So I guess I have a couple of perspectives because of the role that I do and the work that I do, but I also have some lived experience as a person who has served prison time. In one case, I had about $200 worth of methamphetamine, just I think it was just under 7 grams or something like that. And I got a 72-month prison sentence when I went into prison. So I had to serve 49 1/3 months, I believe, on that. Walking the yard with people that had taken lives, driving under the influence, and we're going to be out had less time, sentenced to less time than I was going to have to serve for my sentence. I can tell you from that perspective that even in the prison system, those charges are seen as unfair from the people that are incarcerated, even that where there's a life loss like that. So for my perspective on that, I feel like it would be up in the same area as somebody that sells somebody drugs, and unintentionally that person loses their life. And, you know, generally that's like a 3rd degree or so it gets charged out, I believe. So, and then the other thing is, I guess, with DUIs, there's so much collateral stuff with the driver's license and interlock and all the other things that have to happen. There's some levels of DUI offenses. It almost seems like double jeopardy a little bit with what it takes to actually reestablish your driver's license and take care of all this stuff. But so feelings wise, I guess going back to that, I mean, I kind of went into this and I looked at it, I guess, probably trying to eliminate my feelings as much as possible and look at it logically as much as I possibly could. And you know, but yet at the same time, we bring our feelings with us wherever we go, and they do have some sort of influence over all that we do and say on some level. And so this being my first kind of assignment on the committee was it was a task for sure, but honored to be able to be a part of it. So that's what I got.
Thank you so much for sharing that, Commissioner.
Hey, could I jump in and
Yes,
piggyback
go ahead.
some
Go
of
ahead.
that? I really appreciate your comments and everyone's comments. I think one thing I've been thinking is I think it's really important to hear from people that have different perspectives on this and have come at it from different experiences. So definitely appreciated the comments about the felony DWI statements that were made by the 2 judges. That's got me thinking, so I appreciate that. On the issue about feelings, I mean, one thing that I've been sitting here thinking is, you know, I've been a prosecutor for a number of years, a federal prosecutor and also a defense lawyer. And as a prosecutor, I talk to a lot of victims, and it can be heartbreaking. I'm remembering conversations that I've had with parents of people that have been killed through drug trafficking and other conduct. And I think what I've taken from that is that some victims want the defendant to be killed. Some of them want the defendant to go to prison forever. Some of them also told me that they didn't care because it wouldn't bring their son or daughter back. And it's really, so from that perspective, I guess I approach this as it's always horrible for somebody to be hurt in a crime, and it is very emotional. But I appreciate Commissioner Mazaros's comment that I try to take emotion out of it when deciding issues of sentencing, because it's really hard to predict what a victim is going to feel about what is appropriate. And I think that's the reason why, while it's very important to hear from victims, they can't be the ones that sit in judgment about how to determine a sentence. So that's kind of how I feel about it. And I know everyone personally has the right to have different views about that aspect of it. And then in terms of how I approach this process, I definitely have sort of experience in federal court and not as much in state court. And in federal court, we have a statute that I think is a really great statute. It's 18 U.S.C. 3553A, and it lists out the factors that are to be considered in determining the sentence. And those are the factors that I was thinking about when I was going through this process. Those being, you know, promoting respect for the law, deterrence, making sure that there's, you know, retribution if that needs to happen, making sure that the sentence is not greater than necessary to serve the interests of punishment. And So as I looked at these offenses, I mean, if you saw in the summary, I was, I think, one of the people that mentioned deterrence. I focus a lot on deterrence because when I think public safety, I think, well, the way that we get to public safety is by this crime or the sentence having some impact on deterrence. And so I thought about, does this, you know, incapacitate the person so they can't commit the crime again? Are they likely to commit the crime again? Is it likely to prevent other people from engaging in the same offense? And I'll say I've really struggled with some of these offenses because, you know, those that involve gross negligence, I think, are really tough. If we sentence somebody for a crime involving gross negligence to a very high sentence because it resulted in death, not because the conduct itself was so bad, but because the result of this sort of negligent conduct was death, to me, I kind of feel like that offense doesn't, sentencing someone to a very long sentence for an offense like that doesn't necessarily serve the goal of deterrence. And so those are the kinds of questions that I was asking. I did find this incredibly difficult and frankly would have benefited from this conversation before I did the exercise the first time. And I hope that we remain open to changing our minds about some of these decisions after the discussion today.
Thank you so much for sharing, Commissioner Saxena. I really like the point you mentioned how, as you were a prosecutor, victims also had various different perspectives. Some wanted to kill the defendant, some wanted them to go to prison, others did not care. So when we think about the voices we're speaking for, understand that all voices have differing also opinions as well too. We're gonna have Commissioner Keefe be the last person to speak on this before we move on.
Thank you. I'm a therapist by trade, so I'll start with all the feels and say that this was a very difficult task to do. And I definitely had a lot of anxiety. It was a scary activity to do. And I think actually sitting down and having to literally write down like what rank I thought things needed to be, the weight of what we're doing and the responsibility that we hold really sunk in for me. Being such a small group of people and making decisions for the rest of the state, that really hit home. So I feel like I appreciate the opportunity and really want to take it really seriously. And like Commissioner Saxena said, I think this is a really important conversation to have and hope that we can revisit things as we need to. Coming from the victim advocate perspective, I agree that I think things I was thinking about is that victims really do truly have different perspectives about what the outcome is. Knowing one victim that had, like, their parent was sitting in a building having a staff meeting and a drunk driver ran into the building and killed their parent and multiple people, and what they were looking for, versus another victim who had a family member be killed and someone who was part of that process showed accountability, and that individual now comes to their home for Thanksgiving every year, right? Two very different outcomes. And I think things I was thinking about is that there's, we're talking about what is going to help public safety. We're talking about deterrence. And for me, I'm also thinking about prevention and what it looks like for folks that, as you mentioned, someone might have 21 different charges and they're not getting it, versus someone that might have more capacity to be accountable and to pivot. And so what does that look like and how does that fit into sentencing guidelines? Something that helped me was talking to Nate and looking at the sentencing guidelines and the manual itself, which Commissioner Knudsen also suggested, so thank you very much. But it made me think about the analogy that sometimes when we're thinking about how things are made, like and we're sitting at the table, like who was the table made for and who's able to sit at the table? And if the table doesn't fit for the people that we want there, then maybe the table itself needs to change shape. And so what does that look like for us? And what does that mean about what we can actually recommend? So I think all of those things are running through my mind. And I guess my last thought I will share is that overall, I feel like there's a perspective that I'm holding given all the presentations about incarceration rates and rehabilitation, knowing the direction that we're going with policies and things like that in our state. And as we break these down crime by crime, there's also a lot of perspective about each crimes, like each individual crime that sometimes go against the overall perspective that we might be trying to hold. And that also makes it complicated to make decisions sometimes.
Thank you, Commissioner Keefe. Thank you also for acknowledging the weight of the work that you're all doing today or throughout this whole process. Commissioner Larkin.
I just wanted to say, and I appreciate the comments about victims. I don't purport to speak for victims. Unfortunately, I've not been a victim of that crime. But my comments, I think, have a bigger context in terms of what does the public expect. So I feel like I'm speaking maybe, not for victims as much as just everyone who says, well, I want to know that I'm safe on the road, my kids are safe in the streets. So I'm thinking more about the public, the community, not suggesting that victims should determine, obviously they need to be heard, they're part of the process, but that's not at all what I'm suggesting.
Thank you, Commissioner. So Charlie Selug from MAD, good to be with you all again. So I'm going to zoom us in on one or two, depending on how much time we have, specific offenses to continue the conversation with a particular focus. So there were a variety of offenses to choose from, obviously where you had very different rankings, but even looking at the first one of criminal vehicular homicide, gross negligence, that was true. So let's start there. The plurality, we're saying do not re-rank, it tied with down ranking. But there were also a number of up ranks, one dispositional line, 3 that were other, about guidelines true zero, about restorative justice, about more data on departures being needed. So let's talk about that one and think about and talk together about what values or principles showed up for you when you were thinking about that particular offense, and in particular, what values or principles applied that you think might have implications for how you would rank other offenses that we didn't get to talk about today. I know, Commissioner Saxena, you were mentioning the deterrence or lack of deterrence effect. What would others bring into the conversation about what values or principles were on your mind for CVH gross negligence?
Can I just suggest, since our time is limited, maybe we should just start with the obvious. I mean, we have one where the majority says this should be up-ranked rather than kind of discussing one by one those where.
Oh yeah, I don't think we'll have time to do all of them. It's more. Yeah, I think with limited time, what I would actually propose is to spend time on where there was disagreement in order to elevate what were the reasons behind that. I agree that there were certainly cases where there was agreement, but we're not trying to necessarily get to a full vote on anything, I think, but I'm open to what you and the chair want to proceed with.
I mean, I guess I hadn't thought about it that way. When I saw the results, we have a limited amount of time to move forward with what we're going to do. And so I was looking for areas of agreement to see where did we already agree. And then, so to me, it kind of maybe makes sense to focus on those areas of agreement. And then if somebody feels really strongly about those places where we don't have as much agreement, that we need to hear that view, then I would love to hear that. But I don't know, I was thinking about agreement.
So maybe if you humor me for a minute on the disagreement, and then we can move to the agreement. Would that work for both of you? Or do I start with you?
But I would say make it the whole CVH family instead of just gross negligence.
Sure. Well, I guess maybe we'll start where you were both going, which is what are you noticing about where was there more agreement then? If you want to start on that side. I
mean, I'll start. I'll just say that the criminal vehicular homicide with impairment and a prior, there seemed to be a lot of votes, or a lot of people who thought that that should be upranked. And I was one of those, and I'll say that because one of the things that I think, talking about public perception, I think it's common public perception that if somebody commits a crime and is sentenced and goes to the system, and then they commit another crime and they haven't learned from that prior experience, that they are deserving of more punishment. And so this one was sort of an obvious one to me because this isn't their first offense. They've come back. They've already been driving impaired. They've come back and done it again, and now they have also, that has resulted in the loss of a life. So the harm was just substantial, and their behavior is egregious because they've done it before. So that was, to me, different than the other ones because the other ones could have been a first time driving under the influence kind of thing, or first time for the specific situation. This is not.
Yeah, Vice Chair.
And piggyback on that, I was surprised to see that with a prior and without a prior are both an 8, because throughout our statutes, it's always like the priors ratchet the crime up. So it's very illogical to me that we have them ranked both at an 8. And it seems to me while impaired with a prior should be higher than while impaired. It just seems obvious.
So it sounds so. Looking at the chart, obviously the majority also were in the up rank. Was anyone up ranking for a different reason? Yeah, Commissioner Van.
Sorry, I'm trying to get my computer to work here. Thank you. Yeah, I think just to kind of piggyback on both what the chair and the vice chair are saying, I think when we look at the current guidelines as things sit, a DWI without anything other than it being a DWI is a severity level 7. And the idea that a DWI with a prior that results in death would only be one severity level higher than the underlying driving conduct for which the person's already has on their record or is already part of that crime. It just seems like it's not rational, and it seems very disproportionate because the harm of death does not get any worse than that. And the idea that there's only a separation of one severity level between a felony DWI and a felony CVO homicide with a prior or homicide with while impaired, it just is not rational, and it doesn't make sense to me. And so that was one of the things that just kind of struck me with that.
Commissioner Price, yeah.
Mr. Price.
Madam Chair, just so I understand what the current rules are, the packet we were responding to speaks about guidelines modifier 2G11 increasing the penalty for this crime by 50%. That's this crime, right? So that, I guess, I mean, I suppose if you look at the grid, 50% is well, it's kind of creating a severity level between 8 and 9. I mean, we could do that. We could do that more explicitly, but we already have that, right?
Well, we have it, but I mean, we have that 50%. I think when I was thinking about moving it up, we would take that out and just rank it because it's simpler. It's very clear that this is a higher sentence.
Are you the one that said 8 to 9, or are you a 9?
Oh, I think I couldn't remember. I think I might have said 9.
Okay.
But I don't remember.
I'm just saying we already have 8 to 9. The question is, should we go to 9?
So I think for time we should go either to another offense that you want to talk about, or we can broaden back out to other implications that you're noticing. Is there another offense, Chair or Vice Chair, that you wanted to discuss as an example?
Well, I think we could go down to the what does CVI mean? Like, that's not what the law is anymore. So what is it?
Injury.
Injury. Okay. But it's not that. It's not that. That's not how it's written in the law anymore. So that just like confused me to no end. So CVI or CVO also had, this one is where I do feel we had a lot of variation, and I would be very curious of what the different points of view were on this one. It appears as if gross negligence and while impaired had some support for upranking, and then there's a split on the other two. And I'd be really curious what the thoughts are on that. And
I think that one where the range of conduct can be so different. And I even think, it's very difficult in the case law. There's a definition of what gross negligence means in this context, but then the cases are all over the place. I mean, you've got, one case like, well, you ran a stop sign, that's good enough. Then you've got another case where it's 10 times is egregious in terms of the driving conduct. So I think that's what maybe gets this sort of split, because depending on which cases you've seen, you'd be like, oh, you misjudge, you shouldn't have gone through the light, or, you're racing down the street, swerving in and out, they both get lumped in the same category. So I understand why we're seeing that split here. But I think the way that gets accounted for is in the departures. Downward, where the driving conduct is minimal as compared to other driving conduct in case law that supports a conviction and a executed prison sentence.
And then, Chair, you were noting that the leaving scene and defective maintenance there was less consensus on those two. Does anyone want to speak to if they were supportive of upranking for gross negligence and or well impaired, but not the others? Why? What led to that difference?
it's like Commissioner Middlebrooks.
Yeah,
has her hand up.
Commissioner.
Thank you. Thank you, Madam Chair. I can speak to that. When I was doing the rankings, a lot of what everybody else has said applied to me as well. But I really looked really hard at the culpability of the person versus and the harm. So I was kind of balancing both. And when I looked at culpability in particular, I felt like the both in all of these categories where it's leaving the scene or it's the defective maintenance, the culpability is just, to me, was very different than where they're under the influence or the gross negligence. And it just seemed like there were, if you're looking at the typical offense, that those had less culpability in my mind, for particularly the defective maintenance, because I felt very, very strongly that many of those cases would be really because of people could not afford to get they needed their vehicles, they needed transportation, and they couldn't afford the maintenance. And obviously there's other cases where they just, they could, but they just decided not to do it. But I was really trying hard to look at typical cases when I was looking at these rankings. And that's where I felt that those, in particular, those two just had less culpability.
Yeah.
Commissioner Mueller.
Thank you, Madam Chair. I appreciate all these comments, and I'm learning a lot, and the group that I sort of represent, we're just on the front end, and all of you in the courtroom have to weigh in on all of these different scenarios. And for all of these cases, I can identify individuals, suspects that, my gosh, I feel for. I've written to district court judges saying an individual on a third-degree homicide is a great person. What kind of consideration can we give this individual? And I've also put people in jail for third-degree homicide that are really, really bad people working for the cartel. And so I see both ends of that. And as I did this, I also felt and I didn't write to outrank everything, but I felt like as I'm doing this, I'm going to be painted with the brush as a guy that just wants to outrank everything. I had a couple of questions. One is I had a hard time understanding, and maybe I should have called Nate and asked this, but on some of the stat maxes, they couldn't even, where they were ranked, you couldn't even reach that. And so I wonder if I'm a judge and I'm trying to sentence someone and the stat max is 15 years and it's ranked at a severity level that, 12 years is at the top of the box for an individual with a significant criminal history score. So I'm curious on that. So some of my answers were like, let's just rank it where I feel like it should fall based on the stat max. Some of these though, I appreciate the comments about maybe disparities with financial and the defective equipment. I also looked at that as commercial vehicle, people operating commercial vehicles as opposed to maybe just their personal vehicle. That's where I would see more harm being done and defective equipment on the road. And then the other one was the other one that we were talking about. Damage and what was the second one?
Leaving the scene.
Leaving the scene. Thank you. And then my only comments on that is that's just another act during this. It's, all the stuff that leads up to it. And then another act by the individual that is trying to cover up or trying to get away. And it just shows some more intentionality in that crime that's being committed. So I think in the first part they were talking about on the homicide, I voted to not rank most of them with the exception of the impaired with priors that I felt like should be a 9. Thank you.
And there could be an upward departure if it's, right, if it's not within the grid, the court could do an upward aggravated departure to the statutory max, even though it's not within the grid.
Thank you. I appreciate that. And I had a hard time looking at that, wondering that, then we're putting a judge in a position to come up with aggravating factors to upward depart when if the crime and the criminal history score, you can't even reach that. It would have to be an upward departure to meet the statutorily assigned stat max.
Madam Chair.
Yes.
If I can, so my understanding is when the commission created the sex offender grid, they had a very conscious goal of reaching the stat max by severity level 6+. But never had that as a conscious goal of ranking for the other grids. For the standard grid, basically, it considers statutory maximums in assigning a ranking, but if it doesn't need to, it's not been like a must have like it was on the sex offender grid that the stat max has to be shown on it.
All right, so I'm gonna have to stop this or end this conversation here. I don't think we've had enough conversation about the offenses, so I am asking staff to bring this back onto the agenda for our next meeting. But we're also going to ask you to do another ranking exercise, and we picked the smallest one of those that are coming. So hopefully that is your whatever. That'll balance it out. That'll balance it out. Thank you so much to Charlie and Shamsa for your facilitation this afternoon. I'm going to hand it over to Nate for what's next.
Thank you, Madam Chair. So I just gave you this document yesterday. So if you're a little confused on the document that I'm showing you, I really want to apologize for that. That'll tie into my executive director's report. I can account for all my time in the past month, I swear. But we did just get this to you. So these are, you may be wondering what these offenses have in common. And these offenses basically are failure to register as a predatory offender and certain persons not to possess firearm and ammunition, more commonly, but not quite accurately referred to as felon in possession. And what they have in common, they have two very important things in common. One is there are mandatory minimums that apply to these offenses. So that really presents some ranking challenges. And I suspect that a lot of the conversation that, that you're going to have on these offenses really has to do with what should the interplay be between the sentencing guidelines and mandatory minimum sentences that the legislature's established. So that's one big thing that they have in common. And the other big thing that they have in common is the behavior is not illegal for anybody else to do, right? Nobody else is required to, write to the police periodically and tell them where they're living for failure to register as a predatory offender. And nobody else is prohibited from having a fire. These people are prohibited because of their prior criminal history. So it's really their status of what they've done in the past that's put them in this position of having to either do or avoid doing things that ordinary citizens do not have to do or avoid doing. I just wanted to, so I again, not getting ahead of myself for the executive director's report, we had a very interesting fiscal note that we had to do in the past month that involved changing. I'm going to jump ahead to ineligible persons to possess firearms or ammunition. Just this is to help you understand what you're reading here. So the fiscal note asked us to imagine a world where the definition of crime of violence changed to eliminate drug crimes. So right now, drug crimes, although not necessarily intuitively being violent crimes, are nevertheless on the list. This bill would take drug crimes off. It ended up saving over 200 prison beds out of the 913 prison beds that we estimate are occupied by people who possess firearms or ammunition. So it would be pretty significant, but we have on here, this chart shows you what these, we call them predicate crimes. So what a predicate crime is, it's the crime that got you so you were not eligible to possess a firearm. And then the crime is possessing the firearm. So the predicate crime, not the current crime, is shown here on the chart. And you see there's a lot of 22%. So the second most common category is third or fifth degree controlled substance crime. So that's why there's a big difference there. Also, a really interesting thing to note here is the difference between firearms and ammunition. It's interesting to note whether the person had a subsequent had ever previously been under this mandatory minimum, because there's at least on paper not supposed to be a departure from the mandatory minimum if it's subsequent, but there is a departure allowed if it's not subsequent. So those are some interesting things to look for in terms of the ineligible person to possess firearms or ammunition. And again, that we think that data is pretty interesting. That's data we don't have for failure to register as a predatory offender. So we don't know what the breakdown is. What was the crime that made the defendant be a predatory offender? We haven't done it. It took a lot of work for our staff to look up all those complaints in the firearms cases. We haven't had a chance to do that for predatory offenders. But we do have links here where you can see what all the predatory offenders are. Also, I recommend that you go to this link that says, that tells you what ways registration can be violated. It kind of lists, it's a BCA website, the Predatory Offender Program, that tells you how it can be violated. So you get an idea of, this is not necessarily committing a new crime. Some of these can be very technical, have to, say if you're moving, you have to say if you're moving in advance of when you're moving. So those are some resources that I recommend you look at. So I'm not going to read this to you, but I'm just kind of pointing these things out. Another thing that is interesting in the predatory offender realm is there was recently a predatory offender statutory framework working group. Full disclosure, I was on that working group. And there is a recommendation with respect to the mandatory minimum penalty scheme that came out of that working group. There was a minority report from the law enforcement members on that working group, and I referenced that as well. So just some things to look for. Again, not getting too deeply in the weeds here. I know you can all read, but I just want to point out some things that you might find helpful as you're going through this. Same worksheets as usual. I actually don't recall if we discussed what a good deadline would be, but last time I think we gave you 2 weeks, and 2 weeks plus a weekend. So that would be 2 weeks from next Monday. if that still works for you. I don't know if anybody has the. Yeah, the next meeting is 4 weeks from now, so it should work if it's 2 weeks from next Monday. So that would be the 28th. That gives us 3 days, but it is a small packet, so I think we can do that. 28th, please. All right, and then so I think that's all I had on that, Madam Chair. I mean, unless there's more detail, but no short on time.
Any questions? All right. We'll go ahead and move on to the executive director's report and legislative update. And if you want to give the word for public input.
Thank you, Madam Chair. So if there are any members of the public who are interested in making, letting the commission know, and I should say, if there are any members of the public who are online who would like to make a statement, looks like you all should be able to raise your hand. So please raise your hand at this time and we'll call on you during that period of time. Obviously, anybody who's in the room who would like to make a statement can do that at this time. So in the past month, it really feels like to me that about a month ago, there was a special election in Roseville. And at that time, the House of Representatives became complete. And I feel like the session really began. We got approximately over 40 fiscal notes in the past month that we had to do. I see, Commissioner Middlebrook nodding her head. She was also on the receiving end of those. Some of them were very complex, like the one I just described with, changing the definition of crime of violence. There were several other very complex fiscal notes. So we've been really, really absorbed in that as staff. One thing to know about those is that we will be able to prepare at least, I believe, one demographic impact statement, if possibly more. But I think on that felony in possession, we should be able to do a demographic impact statement based on the methodology by which we estimated those 222 prison beds. So we should be able to come up with an estimate as to the demographic profile of the occupants of who would have been in those prison beds, basically. So, and we do prepare demographic impact statements pursuant to the commission's policy. The commission members themselves actually have an opportunity to participate in that process if you'd like to participate. I will say it could slow the process down, but we welcome any commission members who would like to avail themselves of that. You just have to let me know by email. Just say I'd like to participate in the DIS process or the demographic impact statement process, and we'll be happy to loop you in on that. Otherwise, we do present them to the commission. So assuming we get it done between now and the next meeting, include those in the commission meeting materials for next month. The other thing, I don't know if I want to speak out of turn, and Commissioner Knudsen, do you have any announcements for the commission at this time?
On what?
On your tenure, sir.
Oh, that. Yes, I'm retiring effective July 7th. So age caught up to me and they're booting me out. So.
Well, congratulations, sir. So that, for those who may recall, the legislature changed the appointment authority for the district court judge. So that will be appointed by the Judicial Council upon recommendation of the Minnesota Judicial District Judges Association. Minnesota District Judges Association, MDAGA. So, and I don't know where that is in the process, but hopefully they're on it, and we won't have a big gap there without a district court judge on the commission. All right, Madam Chair, that concludes my report.
All right. Judge Knudsen doesn't know it yet, but we're not going to let him retire. So we're just going to keep making him attend the meetings going forward. He's been really integral to the steering committee, that's for sure. And I'm really sad about the timing of this.
Well, thank you.
That takes us to public input. Is there anyone present who would like to make a statement or provide input to the commission today?
There's no one online in that position, Madam Chair.
All right. I'm not seeing anyone in the room either. So with that said, our next meeting is Thursday, May 8th. So we will see you in a month. And unless there's any objection, this meeting is adjourned.
Thank you, Madam
Thank you,
Chair.
everyone.
Thank you.
I gotta scoot, I gotta come up on that.
Thank you.